Denise Howell here, and you're about to listen to This Week in Law. This week, we've got Matt Schruers, Michael Weinberg, and Venkat Balasubramani joining me. We're going to talk about tweets and monkeys without copyright, felony K-cut deviations, fallout of Aereo and net neutrality, and lots more on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is Twill, This Week in Law with Denise Howell and Evan Brown, episode 270, recorded August 8th, 2014. 3D Nato and the Selfie of Doom. This episode of This Week in Law is brought to you by Personal Capital. With Personal Capital, you'll finally have all your financial life in one place and get a clear view of everything you own. Best of all, it's free. To sign up, go to personalcapital.com/twill. Hi, folks. Denise Howell here, and you're joining us for This Week in Law. Happy summer to you. We're so glad that you're taking the time out to join us today because we have a slew of great topics to discuss and some really wonderful people to chew through these difficult topics at the intersection of technology and law. Returning to the show, the Vice President of Public Knowledge and 3D printing expert extraordinaire is Michael Weinberg. Hello, Michael. Great to see you.
Hello. Good to see you, too.
Great to have you back. Lots going on in Washington these days.
Lots going on in Washington these days. Everyone is busy. Everyone who's in town is busy. Everyone who's away is just on vacation hanging out.
All right. Well, I'm not sure how much away and hanging out you can be doing when you're getting pestered by public knowledge to come and help deal with some of the heady issues that you guys are plowing through here in the month of August. Also in Washington, D.C., probably not too far from Michael, is Matt Schruers, who is the VP of Law and Policy at the Computer and Communications Industry Association. That's CCIA, for those of you into acronyms. He's also a professor at Georgetown Law in its program on communication, culture, and technology. And he writes for a really wonderful blog for people who watch the show, follow the show. You've probably already come across the Project Disco blog, which has great coverage of the kinds of things that we like to talk about here each week. So, Matt, great to have you on the show.
Thanks. Good to be here.
How are things at Georgetown these days?
Oh, well, yeah, unlike Washington, which never actually gets quiet in the summer, the nice thing of the academic calendar is that it actually does get quiet in the summer. And so this is when all the full-time faculty go off and do, symposias and conferences, and those of us who are just adjuncts and pretend to be faculty in the evening, get back to our day jobs.
Wonderful. What are you teaching in the fall?
In the fall, I'll be going back to my intellectual property survey course, which I always enjoy a lot. It's intellectual property for non-lawyers in a communications and technology program in the grad school. And so it's one of a handful of programs that is trying to familiarize non-lawyers with legal subjects that are increasingly unavoidable in the business marketplace, right? You just can't get away from IP in so many aspects of business today. And so it's, I think, a good idea to try and familiarize folks with issues that they may encounter, even if they're not practicing law, but might have to negotiate nonetheless.
Well, you couldn't be a more perfect fit for our show because that's exactly what we try and do here is get people to understand what's going on and highlight issues that if they haven't already come to their attention will soon and are important to them. And also returning to the show, one of our favorite friends and guests, Venkat Balasubramani. Hello, Venkat.
Hey, Denise. Hey, everybody.
Great to see you.
Likewise. Thanks for having me.
Venkat writes for Eric Goldman's technology and marketing blog and is a lawyer at Focal. He's up in Seattle. Anything else going on with you these days, Venkat?
No, but I did have the opportunity recently to convene with Eric Goldman, my co-blogger, in Whistler, British Columbia, and that was super fun. You have these online exchanges that span a long time, and I've met him before, but it's always fun to meet people face-to-face that you chat with, over Skype or online, so I thought I'd mention that.
Yeah, that's really cool. I think I'm in the same boat that I feel like I know Eric well and consider him a great friend and great friend of the show for sure. And I don't believe I've ever met him in person. So that's the world we live in today. Let's go right into some interesting copyright stories. We always love talking about 3D printing when Michael's here with us. It's such a great opportunity because he's one of the foremost experts in the world on the legal issues affecting 3D printing. So let's go there first. There are a few different things we could touch on. First of all, the government is trying to make 3D printing files more widely available. Can you tell us about that, Michael?
Yeah, this is a really exciting thing that's happening right now. A couple of months ago, an office in the White House, the Office of Science Technology Policy, helped put out a memo from the White House to the entire government that basically said, take steps to put any 3D files you have up online. And if you have stuff that could be scanned, scan it and put it up online. And this is great both because it's federal government stuff, which means it's not protected by copyright. It's basically, it's ours already. And then also the federal government has a lot of stuff. And so you could see a world full of all these 3D printable objects that you could explode and really expand the number of things that you can do with a 3D printer. And so in the months since, we have seen something of a scramble among different pieces of the federal government to start to get their stuff online. And so we're seeing the Smithsonian Institution get some of their stuff online, the NIH get some of their stuff up online, and NASA get some of their stuff online. And it's neat to watch them because they're all doing it kind of differently. Often people think of the federal government as kind of like a big monolithic place, but actually it's very sprawling in a lot of ways. And so these folks are, in touch with each other, but they are essentially running independent shops of trying to figure out how to do this. So you've got the Smithsonian Institution that has a massive physical archive that is working on scanning those things and putting them up online. So you have Abraham Lincoln's death mask, or you have Amelia Earhart's flight suit, or airplanes, or whale bones, or woolly mammoth skeletons. And then you've got the NIH, which has this combination of medical things that have been generated from data sets. So they have these super intense visualizations of bacteria, or they have learning model, kind of simplified versions for people like me who don't know what bacteria should really look like. And then even some lab tools. And then NASA has all sorts of stuff. They have scans of asteroids. They have kind of renderings of satellite dishes, and all of these are available for free and download, and they're all trying to put more stuff up. So it's a great time to watch this happen in the federal government.
It's really, really cool. I hadn't even thought about all of the things that they might be able to make available. So thanks for giving us some of those examples. On the receiving end, does anyone really have a 3D printer yet that could print out a woolly mammoth skeleton?
I don't know that anyone has easy access to one that could happen at scale. Although, there are programs that will slice it up. I guess you could just print it in tiny little pieces. There's a great project called We the Printers that some people are doing where they're taking a bust scan. The first one they did was George Washington, and they took a full-size, actually more than full-size bust of George Washington from a library, a museum in Baltimore, and they chopped it up into a bunch of 4x4-inch squares and had people all over the world print out their own 4x4-inch square and then send it to them, and then they kind of pieced it all together. So I guess you could do the same kind of thing with a woolly mammoth skeleton. But for now, I think you're mostly talking about printing out smaller replicas if you're on your own and you have limited amounts of time.
As Lego projects go, that sounds like definitely in the 14 and up category.
Yeah, that would be an epic adventure.
All right. Well, another thing you highlighted recently on Twitter that I thought was really cool about, things you could do with 3D printers. And maybe this is something we could see rolling off of NASA in a more detailed and to scale version. But there's a Mars rover on Thingiverse now. I believe it's a toy Mars rover, right? This isn't to scale.
Yeah, there's a toy Mars rover, and this is cool for a couple of reasons. One, I mean, it's up on the screen there. It's a really detailed version of it, and you could print it out and assemble it. But also, and yeah, you see there are all the different pieces. It's broken up, so you don't print it as one model. You print it as some pieces and then assemble it. But actually, they released probably 3 or 4 years ago a different model of the Mars rover that was much less intricate. It basically was as good a model as you could print on a desktop 3D printer a couple of years ago. And to see this one, the improvement is it's an incredible leap of quality, even at the desktop level. And so in addition to being just neat in and of itself, it's a really good way to track the evolution of what's possible with a desktop 3D printer. And it's just getting so much better, so much faster.
Are there national security and or sort of trade secret considerations that come into play as far as what the government will release? Obviously, there must be.
Yeah, I'm sure there are. I mean, there are plenty of things there are plenty of physical objects that the government has that I don't think they're going to be scrambling to be releasing. I don't think, you'll be printing out weapons systems from the Department of Defense anytime soon. But there are plenty of things in that other category that are fine. I mean, you just kind of go down the list. I mean, imagine all the samples that the EPA has, for example. The Department of the Interior, they probably have both artifacts and they may have scans of like huge areas. It's not hard to imagine the technology is certainly out there to scan, like all sorts of national parks or the Grand Canyon or something like that, and then be able to render that and take it and, you could print it at home or you could imagine it being in a classroom. And so as you start thinking of all the nooks and crannies in the federal government of places where they may already have this data for various reasons, it's a huge treasure trove of information.
And you touched on the fact that because these are government properties, they're in the public domain. Are there some nuances to that? Are there some things where the government or someone retained by the government might assert a copyright in these kinds of items?
Yeah, I mean, so generally speaking, and I want to say just no, there are no nuances whatsoever. If it's done by the federal government, it's not eligible for copyright protection. Unfortunately, it can get complicated if something is the creation of a contractor. And so the person is not actually part of the federal government. We and a number of people have been talking to the federal government about finding a better way to label those things, because it should be, because government works are not eligible for copyright protection. It should be that if you go to a government website, if you find some sort of government resource, you should just be confident that it's in the public domain and you can do whatever you want with it. But because you sometimes have to worry, there should be a better way to figure it out. We were working with some people who were even just trying to download all the headshots of the members of Congress. And they were a little bit worried that, what if Congress had brought in an outside contractor? They couldn't assume they were in the public domain. And so we got in touch with the General Services Administration and they walked us through it and they said it was fine. But it's a shame that it had to go that far. It would be so much easier if there was some sort of mark, almost like a Creative Commons public domain kind of mark that would go on these materials. And so people would just know and be confident that they are available and in the public domain. But short of that, I think most of the stuff on these sites for Smithsonian and for NIH, certainly for NIH and for NASA, it's in the public domain. So go download, print it, have fun with them.
Have you ever paid attention to the White House's Flickr stream and the copyright notice that they apply there?
Yes, I'm so angry about that. I have an angry blog post about that.
Tell us about that.
Yeah, and this is actually, the White House does this, and many parts of Congress, especially committees, do this, where they have this weird disclaimer on it that it doesn't explicitly claim copyright. It just lists a bunch of restrictions on what you can do. They say, this is only for personal use or for news gathering purposes. You can't use it for this whole other list of things or to imply endorsement. And the result is kind of a chilling effect for people who should be able to just use it. I mean, on one hand, you understand why someone in the government decided they should list all of these possible restrictions. But you take that to its extreme, there are all sorts of things you can't do with an official White House photograph, right? You can't use it as part of mail fraud. That doesn't necessarily mean you should put a warning up on the site. Say, oh, you can't use this for mail fraud. You can't use it in some sort of elaborate assault on somebody. No, you should just say, look, this is in the public domain, and you can use it as you see fit. And so we've been also talking to the White House and to some of the congressional committees who have both photographs and video streams of their proceedings to make it super clear to people that these are in the public domain and you can do whatever you want with them, of course, subject to existing criminal statutes and other random things that would apply just generically across the board.
Right. Here's what it says now. There's a link to, as far as the copyright notice goes, they have a link to the U.S. government work page that explains what a U.S. government work is. But then it looks like for every picture, they have text in the description of the picture that says this official White House photograph is being made available only for publication by news organizations and or for personal use. Printing by the subjects.
Which is bogus.
Right. The photograph may not be manipulated in any way and may not be used in commercial or political materials, advertisements, emails, products, promotions that in any way suggest approval or endorsement of the president, the first family, or the White House. So, yeah, that seems like not consistent with the actual government work copyright page that they link to.
Can I offer a thought on that?
Oh, go ahead.
This is the copyright. This sort of, sometimes people call it copyright abuse. Sometimes people refer to it as copy fraud. And I don't think this is as egregious an example. But you can open any just about any published book, and you can often find an extended paragraph in the formatter that attempts to control what you can do with the book, including things like do not introduce into an electronic retrieval system, right? Which is essentially what we've recently found out from federal courts is lawful under copyright because of the Google Books litigation, or all sorts of other crazy things. And the sports leagues have similar things that they say you cannot do. Just because the demand is made doesn't mean that the demand is enforceable. And it's just I think an example of the copyright law is supposed to work as an incentive, but here the White House has totally understandable desires about information control, that they don't want people to say use photos of the first family to imply endorsement of some product. But copyright law really isn't the mechanism to achieve that, and so you have this language that's sort of been crafted to imply that could still that's still controlled, by the Copyright Act, as opposed to say, some other provision of the law.
Right. Is it too much to expect precision on copyright law from the White House? I don't know. Maybe it is. It seems like
should not be.
Should be a
years
nice
ago,
example for the rest of the country.
Years ago, we actually complained about this, and I had some dealings with the FTC, and generally a lot of the folks who were engaging in this kind of activity said, well, it's just too complicated to explain to everybody how things work, so we'll just use some very officious language and hope nothing is, people don't do anything wrong.
We'll just scare everyone away.
Right.
Yeah.
Right.
Well, that's a sad thing, but I'm glad, Michael, that you're paying attention to how the government is rolling out its 3D printing resources. That seems like, we're just at the tip of the iceberg of how great those resources are going to be. Let's talk about Amazon's 3D printing store, which people may not be aware. There is one on Amazon now. They're calling it they say Shop the Future. And it's like Thingiverse, but you pay for things, right, Michael?
Yeah, it's sort of a hybrid between Thingiverse and what a company called Shapeways does. So Amazon got into 3D printing a couple months ago when they started selling 3D printers and sort of equipment for 3D printers. And now they're dipping a toe even further in. And this is it's not quite like Thingiverse where there's a huge range of stuff. There's sort of a limited universe of things, but those things are all customizable. So you can go and you can find and you can change the design on thing or change the colors, the patterns, and they'll print them out and they'll ship them to you. And so it's a good step for 3D printing. It'll be interesting to see as Amazon gets more engaged with 3D printing, how they decide to go about it. But it certainly is a suggestion that their first 3D printing store was successful enough to justify kind of building a second version of it.
Venkat, what do you think about the copyright compliance that Amazon will have to do in determining what they're allowing for sale in its 3D printing store?
That's a good question. I imagine they will take the route of, standing behind their DMCA policy, and that should offer them some level of protection, but not necessarily 100%. I imagine they're selling designs that third parties upload or offer. I haven't taken a close look at the store, but to the extent they do that, it's probably somewhat similar to their existing marketplace that deals with trademark and other claims in addition to copyright claims. So I think some sort of a notice takedown is what they will do. And I think it'll be interesting to see in the future what sorts of claims people assert and to what extent the takedown regime allows Amazon to escape liability. And I must confess, I have a very limited understanding of the scope of IP protection over 3D printing. So, Michael, if Michael wants to chime in, I'm very curious to hear his thoughts on that as well.
Yeah, I mean, I think for them, this is a slow process, so it's a very curated marketplace. And so I would be surprised if they didn't have a business relationship with almost everything that is featured. The question about what happens as those marketplaces scale becomes interesting, especially, I mean, like you said, it depends on who does the printing, because as a virtual space, at least on some level, they do have DMCA protection. But if they're then manufacturing the object, it becomes an interesting question as to if the DMCA protection that would protect them, if they were YouTube and streaming a video, extends to them printing and sending an object.
Right. And I think a case that involved Cafe Press recently that sort of didn't touch directly on this issue, but talked about online versus offline protection for the DMCA, kind of raised these interesting issues. And a bunch of people filed an amicus brief that I actually tangentially helped write as well. And I think that area of the law is very interesting, and 3D printing will definitely, have a lot of nuances.
Matt, your colleague at Project Disco, Sarah Lai Sterling, who I'm pretty sure we've had on the show before, has a great article on copyright compliance and Etsy, which faces similar kinds of issues where, they're dealing with a whole vast universe of people submitting items for sale, and there's only so much vetting they can do and so many terms they can get people to, automatically click through without reading and not necessarily understand their obligations as submitters. Do you think that Amazon is opening a can of worms here?
No, not particularly. And in fact, I think the Cafe Press is sort of a similar situation here, and I don't think we see Cafe Press as being particularly rebellious in their sort of legal activities. It's just providing a service at the other end of the network, and so I see 3D printing as a natural evolution of that. And so for that reason, it would make sense that the DMCA would still apply, that the regular having a DMCA policy on the at the platform would solve the sorts of problems that we might expect to arise here. And Amazon or anyone who's offering sort of third-party hosted 3D printing is going to have to rely upon claims by rights holders saying, I own this, it needs to come down, because it's simply not possible for any intermediary to vet and validate who owns what when you're dealing in such large amounts of content. If you go back and read the legislative history of the Digital Millennium Copyright Act, which I'm sure everybody does, they
every weekend.
Right, I know. I got mine by my desk.
I'll see you tonight, Matt.
Yeah.
It's our group reading Friday night.
Your book clubs in DC must be pretty funny.
Yeah,
they're hot.
But there's this part in there where Congress is saying, there's 800,000 links in Yahoo, and how could anybody possibly police that? Right? It was 1998. And they were worried about 800,000 links. Now the indexable web is in the billions, and so you simply need to we need to have this kind of system where the intermediaries are reactive. They do what they're told to do when they're told to take things down. And I think Amazon will have to be in the same position. So I'm sure they're up on their DMCA compliance, or they wouldn't be launching this.
I think one point that's just worth highlighting for viewers is that the DMCA applies to copyright claims, and I think trademark claims have sort of followed suit, and most intermediaries have implemented a notice and takedown, and for the most part achieved similar protection, even though there's no special statute that protects intermediaries. And I don't know to what extent 3D printing will implicate just copyright claims. I assume the designs themselves will have copyright protection, but presumably whatever objects that are produced could have other, I don't know if patents, I'm assuming patents will figure in as well as other rights. So I think that's worth clarifying for everybody that, the DMCA deals with copyright, and that's a big chunk of it, but that's not the entire story.
It's really interesting to watch. You're right that DMCA is only copyright, and all these companies that are doing the printing, and even someone like Etsy, they get trademark claims. In 3D printing, you're definitely going to start to see more patent claims. And those trademark owners and those patent owners, they tend to just sort of do a quasi DMCA process where they send a letter and the site complies and it gets taken down. It's kind of been built into the social norms of rights holders and websites. And it's an open question. You certainly hear people starting to talk about it, whether or not at some point that'll need to be formalized in a DMTA or DMPA that formally builds a notice and takedown structure around trademark complaints or patent complaints. But in the absence of that, it's kind of interesting. I don't know that I would have expected it to be so ingrained into lawyerly social norms that they just send what look like properly formatted DMCA takedown requests for patent things and trademark things.
It's sort of wishful thinking, probably.
Well, it's not always wishful thinking in the sense that a lot of services do honor what they perceive to be valid complaints, even though the complaint compliance is not required by the DMCA. So there are platforms that will honor trademark-related takedowns if they think that the complainant is within their rights. But you also don't necessarily want mandated DMTA, for example, because you could imagine what you see a lot of the luxury goods vendors doing in Europe happening here in the U.S., where they decide that high-priced handbags or leather goods. I don't know. I'm not really an expert in these things, but they always seem to be the plaintiffs in these cases. Shouldn't be sold online or shouldn't be sold secondhand. There was a long attempt by certain luxury goods owners to go after eBay. eBay ultimately prevailed in that litigation. But they certainly didn't want their goods being sold online. They wanted to be able to control aftermarkets for their own goods. And unfortunately, I think those efforts have largely failed. But you could see them recurring if you had something institutionalized, like legally required notice and takedown. So right now, we just sort of have an informal practice, or you might even call it a gentleman's agreement among these industries that they seem to honor legitimate ones in some cases. But in a lot of environments, that's not going to work. You wouldn't want to see Disney running around, for example, filing takedowns on the basis of people selling used Disney lunchboxes or whatnot.
No, we wouldn't have an internet left if you had to take down all the Disneyana and various other things that are being resold. Yeah, I was unaware that there had been a big scuffle with luxury goods manufacturers and eBay. That's fascinating. And of course, it sounds like the right legal decision for eBay to prevail, but it makes perfect sense that there's at least attention paid there, because I don't know. I mean, obviously you said, Matt, you're not a big expert on the leather goods. I'm not a big expert on them either, but I do, from time to time go into a department store and it just floors me that, you can buy a handbag for $10,000.
Right, right.
You can.
Just think how much money you could, as a vendor, think how much money you're afraid you're losing from those secondary sales, right? Even if only 1 in 10 of your goods that's bought used might have been purchased as a primary sale, that's still a non-trivial amount of sales that you could make. And so if you could reach out into the aftermarket and control all those sales and stop all those transactions, you could make a lot of money. But it would basically mean that people who bought their stuff don't really own their stuff because they can't sell it. Fortunately, right. I think U.S. law is pretty hostile to that notion.
Well, I think we'll have a chance to talk about that a little bit more when we talk about cell phone unlocking later in the show. But right now, let's wrap up our copyright stories and have Matt tell us about your session with the House, right? You were in the House hearing this very week, I think, on copyright damages.
That's right. Yes. A number of folks, including Michael's colleague Sherwin, and I were testifying before the House Judiciary Committee, which has had a long string of hearings now. Someone told me that they're up to 15 or 16 hearings exploring various aspects of U.S. copyright law. This particular hearing was focused on remedies, and primarily 2 issues came to the, I should say 3, came to the forefront in the hearing. One was about the so-called felony streaming issue. Another one, which I was principally focusing on, was about statutory damages. And the third issue was about a proposal to have a small claims court for copyright. And they're all, very different issues, but all fell under this common heading of remedies for under the Copyright Act. So the committee decided to sort of bundle these subjects up and bring a bunch of folks in to talk about it. Each one's kind of a different kettle of fish.
Right, exactly. Tell us about felony streaming.
Right. So due to a quirk in how, well, I shouldn't say this. There's you could characterize it a quirk, or you could characterize it as sort of intentional policy. Right now, sort of for criminal copyright enforcement, the felony penalties are only available for reproduction and distribution. So they'll step back a little bit. The Copyright Act isn't just the right to make copies. It's a bundle of rights: reproduction, distribution, the right to make derivative works, the right to publicly perform. And those bundles are really what the copyright holder controls. And so that means a lot of different things. It means the right to make copies of the book, but also to sell the book in the bookstore, to have the Hollywood adaptation, or even the lunchbox, right? Those are all exercises of the copyright. So when our felony copyright penalties were created, they only applied to the reproduction and distribution rights, and which sort of makes sense, because at the time that's most of what was happening with respect to criminal piracy enterprises. They were actually making unauthorized copies of things and selling them. But now the concern is that more criminal enterprises are unlawfully streaming things online. And one of the big complainants in this area are folks who do sort of pay-per-view streaming of things like niche sports. These cage matches where they put two guys in a cage and they beat the pulp out of each other is apparently, that the primary business model there is streaming. And so if those streams are getting hijacked and restreamed by an infringing site, that's a big problem. And yet under the current interpretations of the law, only misdemeanor penalties can apply. And so these online streaming folks are saying, well, hey, why shouldn't we get as much protection as the publishers who publish Harry Potter? And so that's sort of the issue that's before Congress now. It's been kicked around. It came up during the ill-fated Stop Online Piracy Act debate a couple years ago, and crashed and burned when that bill went down as well. And so now it's just sort of coming back.
Okay. How about well, let me ask you this before we go into more of the details of the hearing. Overall, do you feel like the fact that there is this stream of hearings that's been going on means that we're actually going to see some movement on copyright reform?
No. That's the short answer. I don't. Here's why.
Now I has a sad.
Yeah. I think that if there's a lot of aspects of how we structure the current copyright system that really could be improved. We could also make it far worse. And if you look at how hard it was for Congress to fix something that everyone realized was ridiculous, the cell phone unlocking problem that you talked about, which was not Congress's intent. They had no desire to control people's ability to resell their phone, and yet that was an unintended side effect of the DMCA. And yet it took years to get a tiny, imperfect fix into the statute. And so given how long it took to solve that one problem, I'm not optimistic that Congress in its current condition can sort of effectively resolve the numerous issues that are out there, right? Because we're there 16 hearings have dealt with far more than or 15, far more than that number of issues, right? And there are as many complexities in music licensing as there are in the remedies area. And so I see a comprehensive reform as unlikely. I do think there will be an effort to try and fix some narrow issues, and it's possible that those items could sort of be broken off and legislated separately. But I'm just, if I had to bet on it, I'd bet against a comprehensive reform, at least any time in the near future.
Yeah, there seems to be consensus on that point. Let's look at why, Matt, I need to know why Michelle Schacht did a non-existent song named after you. Tell us about that.
I know that's my it was 45 seconds, so it was my 45 seconds of fame right there.
What happened there?
So a number of folks put together a briefing for Hill staff about the ASCAP and BMI, which are the big performing rights organizations here in the United States, that more or less control about 90% of the performance rights. So when things get played on the radio or television or certain online services, these are the entities that collect the money and hand it out to artists. So basically, you have sort of two organizations that have acquired almost all the rights in the country, and they pretty much set prices, right? So the Department of Justice didn't take kindly to that in the mid-20th century, and so they sued these guys for being cartels, essentially. On the other hand, they also acknowledged that they were sort of serving an important role, and so what's happened is they now operate under antitrust consent decrees. So they are sort of functionally constrained about what they can do and what they can't do, so they can continue to sort of do the transaction cost reduction that needs to happen for music to be played on the radio or other services, but also do so in some way that's sort of supervised by antitrust authorities, right? So these consent decrees are out there, and they're both kind of dated by now. ASCAP's was updated about 12 or 13 years ago, and they're not functioning particularly well. There's been a number of cases brought where federal district courts have said, yes, it looks like these PROs are acting anti-competitively, notwithstanding the consent decree. And so the Department of Justice, on its own accord, said, hey, we're going to take a look at these consent decrees. So we put together this panel on the Hill to brief folks. And at some point along in the way, some fella got upset, sort of made a scene, threw some T-shirts at us and stormed out, and later blogged about it. And a number of the details were wrong, and the whole thing got billed as a congressional hearing, which it wasn't. In any event, so Michelle Schacht read this and decided that those of us who had participated in the event and a bunch of other, frankly random folks, general counsels for companies, some fellow who writes for Yahoo Music, we were all the bad guys, and so I guess the 12 horsemen of the music apocalypse or something, and we're all now title tracks. So I'm. Yeah, I guess I'm still waiting for her to come to me and ask for a publicity rights license.
Right, exactly. Isn't there, there's some precedent for what she did. She didn't actually put anything in these tracks. They're silent. And I recall
right. And so it's actually, it's a crafty idea. I think some other artists have done this before, and they put silent tracks on an online service. In this case, it was Spotify. And when those tracks play, Spotify has to pay. They basically pay out the for the performance rights. Right. And so what she said is, well, if people play this music, it will fund my tour. And the idea is that because it's silent music, you could just sort of leave it playing on overnight indefinitely. And I guess Spotify will compensate folks. Now, someone else did this, but I think Spotify took issue with it. That wasn't quite what they had in mind in offering their service. So it came down. I actually haven't checked if you can still listen to 45 seconds of Matt Shears in silence on Spotify.
All right. Well, someone please check for us. And I think the other band that did this, or the one we talked about on the show, was called Wolfpack, maybe?
Yes,
Wolfpack.
That's right. And I gather they actually did make some money off that. So, it was an inventive technique for getting their tour funded.
It was certainly inventive. Let's talk about the copyrightability of a couple of things near and dear to people's hearts. The first being tweets. This is something that's come up again and again on the show, with the teeing up the issue being, could you have a copyright in something so brief and oftentimes informational rather than creative? Of course, there are so many different creative uses of tweets. I was just reading in Wired magazine yesterday about a guy, I'm forgetting his name now, who published an entire short story by having his friends initially tweet sentences of the story, and then he would retweet them. So it looked like he was gathering them from around the web. Certainly, this seems like a very creative use and something that, might be able to trigger a copyright, but maybe other tweets might not. So over at TechDirt, Gabriel Miller, who writes there, decided to do an experiment. Back in January, he had an exchange about A.O. Scott, who is a film critic for the New York Times. And A.O. Scott got upset because a couple of lines of one of his tweets were pulled out and used by a film promoter as part of a full-page ad promoting the film. I have the feeling this kind of thing happens all the time. It's one of the hazards of working at the New York Times. If you positively review something, people are going to pull out and want to use that to advertise their wares, whatever they may be. Here, there was a discussion about whether you could actually use copyright, getting back to maybe using copyright law for more purposes than it was intended, to pull down the tweet under the DMCA. So, you could go back and forth on that issue, but the experiment that Gabriel did was to take one of his own tweets, pay $35, send it into the Copyright Office and try and get it registered. I'm not sure how long this process took. He said 7 months and $35 later. So I don't think the request was probably pending quite that long. But he got a rejection from the Copyright Office saying, no, sorry, your tweet is not copyrightable. So what can we conclude about the copyrightability of tweets from this, Venkat?
Well, I think it depends to give the typical answer. The Copyright Office rejected. It was a great blog post and a great experiment, by the way, and well worth reading. Rejected his attempt to copyright a tweet and cited the circular that talks about short phrases and expressions not being copyrightable. And he filed a short response or a submission because the copyright registration process allows you to submit comments along with the registration that sort of explained why he thought his tweet number 452 should be eligible for copyright protection, but that didn't change anyone's mind. So there is an appeals process. I don't know exactly what it's called, but it's a couple of $100, and he decided not to spend the money to further push the envelope and see if he could get someone to change their mind. I'm with you. I mean, I think that, short phrases and expressions is just a shorthand to say, things that are not of a certain length we don't think of as being copyrightable, but that's, I think it's just, that's not always the case. I think we can think of creative expressions that are just 5 words long or around that length. And so there's no reason why there should be an absolute bar. So I think it was an interesting anecdotal look at whether or not something that short can be copyrighted. But my recollection is, the law is somewhat mixed, and there are examples of short phrases being accorded copyright protection.
Matt, this kind of example makes me think about whether our whole registration system jibes with technological realities these days anyway. I remember back when I first started blogging in the early 2000s, there were a whole flurry of people and hand-wringing around whether we have to copyright each and every blog post. Send it in, $35 fee, register it. And, this is just a more compressed version of that. Obviously, you don't have to. Well, it's not obvious for people who are not lawyers. This is not all that obvious. You do not have to physically register and pay that fee in order to enjoy copyright protection. But if you ever hope to follow up on your DMCA takedown notice and bring litigation about the thing that you're complaining of, you have to have registered the copyright. So do we need to rethink this whole process?
Well, it's you're sort of getting to the primary tension in copyright law, which is that we want to have the bar low enough so that the incentive to create is a meaningful incentive in the cases where it's necessary. But we also have chosen to have a bar there to some degree for a variety of reasons, including you don't want to have frivolous disputes. You want someone to assess whether or not something was creative before necessarily launching a federal case. And also there's, just like the patent system, there's a good argument to be made for having a list of all these federal entitlements that the government is handing out. And so it's just it's a very challenging time. My argument would be that actually it's never been easier to have a low-cost registration system. And indeed, we could even have a mandatory registration system. There are problems with the fact that every tweet is potentially copyrightable, every email is potentially copyrightable, every photo taken by a non-primate is copyrightable, right? And that's kind of a problem in the sense that there are the potential liabilities attached to every piece of communication on the internet. But I also sort of appreciate the concern as a blogger myself. It's true that when by not registering every post I make, I do sort of forfeit some potential benefits under the law. The Copyright Office has been working to try and solve these sorts of issues, particularly in issues like photographers. They've been rolling out mechanisms for allowing batch filing of large amounts of works, because of course photographers will take thousands of shots in a shoot perhaps, and you can't at $35 for each one of those is just implausible. But my view is that in fact the registration system is more important now than ever, and trying to figure out a way to get people to register what they think requires protection in a low cost and easy way is something that should happen in a copyright reform. But it's also, I think, something that's unlikely to happen because it would be such a radical shift from how we do things now.
Right, and I'll run this by Venkat to fact check myself. Just that if you do decide, okay, this one particular thing that I haven't registered is the one that I'm going to maybe have to sue over, and you register that right before you file suit, that's still perfectly okay, right?
It is. Yep.
Yeah.
In fact, it doesn't really have to be registered, right? Which is to say that you can file the form with the Copyright Office and you don't need to wait for them to get back to you before you initiate your litigation. Now, it might turn out that during the litigation, the Copyright Office comes back to you and says, hey, you know what, that's not protectable, and now you're in trouble.
Yeah.
But your only obligation before going to the federal courthouse is to file the form VA on your Selfie. And that only costs $35.
Right. Michael, any thoughts on this before we move on?
Yeah, just that I think Matt is right that, if we're working in a place, we're in a world where whether or not a tweet can be copyright protected, a lot of things can be. There's a huge value to making sure that we do have like a list of a registry of everything that's protected. And it should be super easy. I mean, especially when you think about photographers or things, there's no technical reason why a low-cost registration couldn't be built into workflow. Right? There's no technical reason why, if you're a photographer, every time you save your photograph in Photoshop or whatever, that automatically registers it with the Copyright Office, and you pay whatever it is, $100, $200, $500 a year to be able to do that. And so, as so many of these things move, or even a blogging platform, right? There's no reason that WordPress couldn't have a plugin that connected directly to the Copyright Office. And if you were a blogger and you were worried about maybe suing someone in the future, you pay some sort of flat fee to be able to connect. And every time you publish a post, it's automatically submitted for registration. So there are a lot of easy, quote unquote, easy technical solutions to the problem of registration as a barrier, because whether or not we can have a long conversation about what should or should not be protected by copyright, but as long as it's protected, there's huge benefits for everyone knowing what it is and who the owner is.
Yeah, I'm worried, I guess, that as more and more people are creating, and I'm using the word creating in a legally significant way, works. And they're people who don't consider themselves conventional authors or photographers, but yet they are out there using the tools that exist to create things. I wonder whether, being given the option to pay $200 a year associated with your Instagram feed is something people would really jump on.
It's sort of the problem we have now with patents, right? That people do come up with inventions and innovations which they may well be disclosing to the public without even necessarily realizing, and yet we don't bestow upon that inventive activity, even though we acknowledge it's sort of in society's interest that it happen. We don't bestow on that activity legal protection unless they've gone through the formalities of filing the patent and prosecuting it, which can cost a lot of money. So, I've always thought it very strange that the hostility that we have towards registration isn't also directed towards the Patent and Trademark Office.
Right. God knows I don't want to open the floodgates of copyright litigation through an automatic registration system, which is certainly what would happen, especially if we have a small claims option.
Indeed.
Yeah.
But that's not where to fight that battle, though, right? I mean, it's not like if you have the registration, it's because the thing is already or probably already eligible for copyright protection. If you're worried about too many people having too many copyrights, the solution for that isn't to make it really hard to identify who owns them. The solution is to dial back how easy it is to get copyright, non-registered copyright protection. But once you've kind of come to terms, and I'm not saying I have come to terms, but once you have come to terms with the boundaries of what's going to be protected by copyright, it feels like there's a lot of upside to be able to know what's in there.
Right. Sue, the writer, is asking in IRC, why should I have to pay to get a right that I supposedly have upon creation of the work? And you're not paying to get the right is the problem. It's kind of a technical distinction because in order to enforce the right, that's when you have to pay. So maybe it's a distinction without a difference.
Well, you certainly do have to pay today, yes, right? You just have to pay to get into the courthouse as opposed to get it automatically. But you're still going to be out $35 at some point if you intend to enforce.
Yes.
But it's a potentially huge benefit, right? If you copyright's pretty powerful.
Because the damages are so high.
Yeah.
Yeah. All right. Well, speaking of things that are copyrightable and subject to high damages and trying to figure all this out and whether or not you're a primate, aren't we all primates actually? Anyway, I don't know. Have to get a zoologist on the phone here. But way back in July of 2011, for those of you who are longtime listeners of the show, you'll remember when we discussed the delightfully cute selfie that was taken by a monkey. When a photographer, I forget if the photographer left the camera there intentionally or lost the camera. Maybe that's significant for the copyright analysis. But the monkey took a photo of itself that is just wonderful. And I'm sorry I did not put it in our rundown to quickly be flashed up on the screen, but someone will do that, I'm sure, and let you know what it looks like for people who are watching. There we go. He's so cute, or she. I'm not sure if we have a female photographer or a male monkey photographer here. So we wound up talking about this story because the person who owned the camera and claims to be the photographer, even though the monkey, in fact, took the picture, has made various efforts to enforce his copyright. And back in 2011, there was not an actual DMCA takedown notice submitted to Mike Masdick at TechDirt, but more like an informal letter from Cater's News saying that it represented David Slater with respect to this photo. And Mike refused to take it down. He went through a whole thing saying, I cannot figure out how you think you have a copyright in this photo. The photographer was the monkey. And so Mike stuck to his guns, did not take it down. And that is what Wikimedia has now done too, because the photo file has been up there for people to use all this time. And when recently they were asked to take it down, they've taken the position that, no, it's in the public domain. So, we're going to go ahead and make Monkey Selfie our first MCLE passphrase for this episode of This Week in Law, because how can we not? If you're listening to the show for continuing legal education credit, we drop these phrases into the show so you can demonstrate that you've actually watched or listened, should you have to. So, Michael, what do you think about the monkey's copyright or anybody else's in this photo?
Yeah, I mean, every joke, every lawyer joke that can be made about this has been made. I think my favorite point that I've seen as it has reemerged, besides talking about if you incentivize creation, is it the first step towards a Planet of the Apes type takeover? Somebody who works here in Washington, Brandon Butler, who's now at American University, who was the first person who flagged this for me, although I suspect was not the first person, to suggest that perhaps this was just a good story gone bad, where the photographer actually took the photograph, and then decided that he would get more attention by saying it was a monkey selfie. And then when he was unable to take it down and it went viral, he sort of stuck in his own trap of lies. I have no idea if that is true or not. And if he is litigious, I hope I do not get a notice of being sued for defamation. But it's a version of the story that, does not feel crazy on its face, that maybe it's a fake selfie, and but he never gets to claim it because he missed that opportunity, which is a lesson for children to always be honest.
Yes, definitely. So we have a law professor with us. Can you shed any light, Matt?
Well, so I think I think Mike Masnick's and Wikimedia's analysis here is entirely correct. The Copyright Office circular on this is pretty unambiguous, and it would apply to other things as well, not just monkeys, but if you have a machine that just generates random patterns or random data, that's not protectable. And there's been cases where businesses have attempted to secure copyright on randomly generated data, and that hasn't been deemed sufficiently creative. It's built into the statute that there needs to be a work. It needs to be an embodiment of originality, and implicit in that is that it comes from a person, which is why this got misreported as the monkey owns the copyright, and then of course there are all these questions about, well, then could I hire thousands of monkeys with thousands of typewriters but that's wrong, right? It's actually that there is no right, which sort of confounds people. The notion, and a number of people have said this, the notion that no one owns it strikes people as foreign. But I think that is the right outcome. But yeah, this is I've said this is sort of like the copyright law's equivalent of Schrodinger's cat, right? Everybody's going to love to talk about the monkey selfie indefinitely. We'll never get away from it.
Have you put it in a law school exam yet?
I have not, but the problem is now everybody's going to do it, and then it'll be like the question.
That's right. It's so unoriginal now. Venkat, any thoughts?
No, just a fun story, definitely, and it's even coming back a couple of years later, it's still as interesting as it was the first time around. So it's fun to hear all the theories and speculation about it.
I will say we had a fight here at the office about, if you had a camera and it was set up to, you pushed a lever and you took the picture, you have the copyright. But then further down the list, okay, so what if you trained the monkey? So you had taught the monkey how to do it. Then might you have copyright? Or what if you put, electrodes in the monkey's brain, so you were actually maybe controlling the monkey? How far you go down the scale of control before you're no longer allowed to say, the rights holder is an interesting thought experiment as you kind of anthropomorphize technology.
What if the monkey is wearing Google Glass and just nods his head? Or, I don't know. You have to tap it, not nod. I don't know, but it's fun to think about, and I had to update you all, for those of you who were listening back in 2011, to let you know that Wikimedia has weighed in on the public domain front. Let's take a break real quick to thank our sponsor for this episode of This Week in Law, which is Personal Capital. Summertime is an amazing time to put personal capital to use for you because your money is very important to you, obviously at all times of the year, but when you're trying to organize summer travel or camps for your kids, you can wind up with some big expenses in the summertime, and you can wind up being out of town, unable to go through your regular process of keeping tabs on your finances. So personal capital could be very convenient for you under those circumstances too, because it solves the two main barriers to growing your wealth. The first is it's hard to keep track of everything. Certainly, it's hard to keep track of everything when you're on vacation. You've got stocks, you've got your 401k, you've got your bank account, and they're probably all on different sites with different usernames and passwords. So goodness knows if you like to leave your computer at home when you're off on vacation and just try and manage things with your phone or your smartwatch, that's going to be an issue for you. The second is you're paying someone to manage your funds, and you might be paying too much. Personal Capital, though, will bring all your accounts and assets together on a single screen on your phone or tablet if you're traveling, or on your computer when you're at home, with real-time and intuitive graphs. Personal Capital has an award-winning watch app too, so this is even more important when you're running around. You can download in Google Play, and it seamlessly integrates with Personal Capital or other Android devices and provides users with relevant and timely updates on their finances whenever and wherever they need it. So you find yourself on a beach in Hawaii, and your stocks are tanking, you're going to get an alert and be able to take some ameliorative measures if need be. Personal Capital shows you how much you're overpaying in fees too, and how to reduce those fees. You also get tailored advice on optimizing your investment. So why wait? Now is the perfect time. Signing up takes just a minute, and it'll pay big dividends. Personal Capital gives you total clarity and transparency to make better investment decisions right away. So go ahead and set up your free account by going to personalcapital.com/twill. Personal Capital is free and the smart way to grow your money. Thank you so much, Personal Capital, for your support of This Week in Law. And let's move on to some more copyright-related issues on the entertainment front. So the Aereo decision came out, almost 2 months ago now. But we've had just a minor development in that case this week when Aereo filed some documents. Eric Gardner over at THR Esquire got hold of them. I think their motion was then withdrawn, so I don't know if those documents are part of the public record any further. But in those documents, Aereo was pleading with the court to give it some kind of relief and sympathy, because there were statements in there about it bleeding to death and having dire financial trouble in light of the Supreme Court's decisions. And Matt, you wrote a really, really nice detailed post the day after the Aereo decision came down over at SCOTUS blog, analyzing the decision. Just amazingly impressive given how long that decision was and how quickly you had such a dead-on analysis on the web for people to be able to try and grok the case and figure out what was going on. You talked about a couple of things in there that I thought we could pull out here, because we haven't really talked about them on the show yet. And one of the points that really struck me in reading through your analysis was this possessor language that the court used, trying to save cloud services in its efforts to limit the case to Aereo's situation only and not to something like Dropbox. The court used language that if you were the owner of or possessor of the media in question, then you would not trigger liability by uploading it to something like Dropbox. I'm paraphrasing and probably getting it wrong, but I thought this possessor language was really interesting because it brings into question, and the whole lockering discussion brings into question things that have been resolved in copyright cases before, and perhaps the Aereo decision actually blows some of those open. The original MP3 tunes case that was very famous at the time had, I think, the largest copyright damages decision of that time. Other things have blown by it since. But MP3 tunes got in trouble because they were letting people rip and then locker their music. Actually, MP3 Tunes was doing a matching process. So maybe it's not quite a one-to-one correlation, but I'm thinking that under the Aereo decision, ripping and lockering, if they're carving that out, might be just fine. What do you think?
I think you're on the specific question. Yes, it was mp3.com. MP3 Tunes is still in litigation about a number of very technical issues. But yeah, the mp3.com case, that was, 12, 13 years ago now.
Right.
They were sued, although the injunction, the lawsuit was filed before the service, as I recall, went live. And what they were doing with the matching on the back end was not quite the same as what's happening now with common cloud services. So MP3 Tunes was actually uploading content on their end, and then when you came in to access that content, if you could prove that you owned it with a CD, they would give you access to content in the cloud. But it was essentially going to be one copy for many users, and as we sort of know from a number of cases now, that won't work. But the cloud model of everyone has access to a copy they created is sort of generally accepted, and Aereo was an example on the edge of that hypothetical, right, where it was being created virtually, remotely, when you would gain access to the file, by virtue of renting a broadcast antenna. So, I don't think MP3.com would have come out differently under this situation, under the Aereo case. Although I do, as you point out, I think the most important takeaway is that there's some ambiguity, although also some encouraging language around that phrase, owner or possessor. So it does seem to suggest that the court thinks putting your stuff lawfully acquired in the cloud is okay. But of course, I mean, as I think most copyright lawyers will immediately start thinking, well, wait a minute, a lot of times people may possess stuff, but they're more accurately described as licensees. You don't own a lot of the media you now have at your fingertips. You're a licensee of it. And so is that covered? No, I think the answer is probably yes. It certainly ought to be yes. And so, but it was language that I suspect was chosen because of this very poorly conceived hypothetical that came up in the oral argument about a valet service for cars. And I think the plaintiffs for the broadcasters went in there with this valet example, saying, if you bring your own car, it's okay for somebody to valet it for you. But if you show up without a car, they can't give you one. And that was sort of an effort to describe Aereo, which fell apart at all sort of detail levels. But it actually, I think, influenced the court's thinking, and that's why we got this weird language in the opinion.
We're going to have to call this episode A Few Years Ago in Law instead of This Week in Law, because we're talking about all these old cases today. But the other one that came to mind
Great
when...
DVD encryption.
Yeah, exactly, that too. The other one that came to mind in reading your analysis of Aereo, Matt, was the Ivy.TV case that was in about the 2011-2012 time frame. Ivy, unlike Aereo, did not have tiny antennas. Instead, they were giving you software that would allow you to do live video streaming of free over-the-air television, broadcast television signals. And Ivy wanted a compulsory license and was shut down at both the trial court and a court of appeals level. So does Ivy somehow spring back to life in the wake of Aereo, do you think?
That's my opinion. It's hard to read the Supreme Court's decision as saying something other than that. I've never said it out. I'm not sure if I've always said it IVI, but but yeah, so they took the position that they were a cable company and tried to get the compulsory license under the Copyright Act. And the court said, no, you're not a cable company. And the appellate court, opinion sort of stood until the Aereo case, where, of course, Aereo was shot down on the basis that they looked a lot like a cable company. And so now, Aereo, this emergency motion that you'd referred to where they said they were bleeding to death was essentially an effort to expedite a determination that they are, in fact, a cable company and they can get the license that the Supreme Court seems to have said they're entitled to. But yeah, it's, my view was that the Ivy case was effectively, sort of overturned sub silentio by Aereo. But, we'll need lower courts to confirm or deny that construction.
Right. And we'll see if Ivy somehow comes back around and decides to exploit this. In the meantime, we've got Aereo supposedly bleeding to death and saying, okay, well, now we're a cable company too, so we'll somehow cobble together the fees to pay that compulsory license and let us survive. But in some of the coverage I've read of that whole issue, there's been an indication that the Copyright Office has telegraphed they don't agree. Michael, have you been paying attention to that? Do you know what the Copyright Office's position has been?
Yeah, I believe that there was a request made by Aereo to the Copyright Office, and in their response, it was sort of like an informal response. Matt probably remembers this better than I do, but the Copyright Office, General Counsel's Office, gave an informal response as part of kind of acknowledging the receipt of the request, where it was read as being very dismissive of Aereo being a cable system for their purposes, which is, of course, one of the major problems with the Aereo decision, where the Supreme Court saying that you are a cable system, so you cannot do what you want to do. And then Aereo tries to say, okay, well, then we'll be a cable system. And places like the Copyright Office say, no, you're not a cable system, which would allow you to do what you want to do. And so they're in this position where it's just like they can't catch a break. There's nothing to do right, because at every turn, wherever the status, cable system or not cable system, they would need to be in order to move forward. That the person deciding that totally in a vacuum, unrelated to the other decisions, decides against them.
So, Matt, do you think that Aereo will be in this kind of rock and hard place position of courts simply telling them whichever way they go, they have no business model, not a legal one anyway?
That's my current concern, that with the Copyright Office's response and their inability to get a decision promptly out of the courts, it is a sort of a rock and a hard place. I've characterized it as which shell is the ball under, right? So Ivy is told you're not a cable system, and so Aereo says, okay, well, we're going to design a system that works this way, and then they go to the Supreme Court and they say, you are a cable system. And so then Aereo goes back to the Copyright Office and says, no, you're not a cable system. It's like, well, you make up your mind, but because you have two different decision makers here, you can essentially have conflicting views. Obviously, there's differences of opinions about how determinative the FCC's views here are as well, because they have some overlapping regulatory authority, but not actually the ability to decide what is a cable system. That's not something that the Telecom Act has a MVPD, is technical terminology here, but I think what the Copyright Office's letter might be read to be doing is sort of lateraling the issue to the FCC for resolution. But yeah, I think it's fair to say that the Copyright Office wasn't supportive of their effort, but they also did not reject the application.
So before we move on from Aereo, the crux of your analysis, Matt, was that although the court tried real hard to say cloud services, you're going to be just fine, there's no way the court could really ensure that would be the case. What do you think likely will happen?
Well, so in the short run, I think what I've referred to as traditional cloud services, where we think of as cloud lockers, putting your regular files in Dropbox or Microsoft SkyDrive or Google Drive and so on. Those services are fine. Those companies can rely on the owner and possessor language, and the court's very vague but determined effort to say that they didn't have anything to worry about. I worry more about newer implementations of cloud services, sort of side loading, certain streaming functionality that we may see built on once, as bandwidth improves. So, like old-fashioned file storage, probably not a problem. Although even there, I can't be certain because the language is somewhat ambiguous in the court's opinion. And I have great concerns about sort of newer features being rolled out. All the research and evidence that I've seen is from scholars talking to investors and innovators, is that folks want to stay away from services that touch media because of the potential copyright exposure. And so I am concerned about the future of new cloud functionality because of this opinion.
All right. Well, we've been in wait and see mode on that, and I guess we will continue to be. One thing we haven't been in wait and see mode because we actually got a determination, the passage of a bill and the signing of a law is cell phone unlocking. So let's look at some law and policy issues around that. So guys in Washington, help us understand the cell phone unlocking bill was passed, but it's kind of a Pyrrhic victory, if that's the right phrase for it, because it's temporary. This is something that enabled a DMCA exemption that will only last possibly for a year because the Register of Copyrights gets to revisit those exemptions every 3 years, and next year is the next time they all come up for renewal. So should we be happy about this? And we've already heard from Matt that the chances of real copyright reform are not that great. So you know, can we at least pop a tiny little bottle of champagne about this? What do you think, Michael?
Yeah, I mean, I think the answer to that is yes. I mean, if nothing else, and we'll get to the substance part of it, this is a situation where the Copyright Office made a bad decision. People went actually to the White House petition site to elevate this issue and say, this is really important. And then we saw the White House get engaged, and ultimately both parties in both houses come together on some sort of compromise and address this. And again, it is an imperfect solution, but for where we're sitting in Washington right now, anytime that we see any level of responsiveness to what is really just like a pure consumer desire is something that should be celebrated. So, and all the people who, you know, we had people who were not only signing the petition, but calling Congress and weighing in on this, you know, calling the White House. This is an example of an issue where the only people who wanted this really were consumers. You know, there wasn't like a big, you know, the big industry players in town were not excited about this, but there was a collection of people who said, no, this is important, we want to do it, and it actually happened. So that's the good news part of it. The reason it's not a kind of flawless victory is, of course, you can always describe a bigger win. And a bigger win, there are two kinds of bigger wins. I mean, the good news is you can unlock your phone, you can get someone to help you unlock your phone, which was in play for a while. The not as good news, the bad news is it's not a permanent exemption. So yeah, we're going to have to work probably the end of this year and next year to make sure that it happens again. And we will hope that the Copyright Office will get the message from Congress that this is the kind of exemption they should be granting. But then, like, the real victory in this would really be a blanket exemption that says, you know, right now, you are not allowed, it's a separate offense to break a digital lock. It's a DMCA offense to break a digital lock that protects copyrighted works. Actually, you know, now we can talk about DVD encryption. And so, but regardless of whether or not you're kind of allowed to access it or that work should be protected. And so what a great victory would look like for this would be an exemption that basically said, if you need to break a digital lock in order to make a legitimate use of a copyright protected work. So if you just want to, you have a DVD that you have and you want to take out a couple clips to, make some political point about what's going on, you're allowed to break that digital lock because the underlying use of the copyrighted work is not illegal. So as long as your underlying use of the copyrighted work is legitimate, then the fact that it's protected by a lock shouldn't prevent you from doing it. That's the real version of the win of this is digital locks don't get in the way of what's allowed under copyright. But that is a longer fight. But I would still say it's still a good win, and we'll take them when we can get them.
So this was one unlocking cell phone bill that passed. There was another one, the Unlocking Technology Act, that would have folded this in, as well as a lot of other considerations, including looking at the whole DMCA exemption process and reviewing the DMCA in general. That has not passed. Is it still alive, Matt? Well,
I suppose it's to be technical. All bills are alive until Congress adjourns. But I think the probability of this issue being revisited once this piece of legislation has gone to the White House and everyone has declared victory is low. Now,
Okay.
I would like to, the odds of any legislation is low at any point in time. But, particularly once an issue is adjudicated, once an issue is addressed by Congress, it tends to cast a long shadow, even if the result isn't necessarily good. Just look at, for example, at patent reform. We had a major patent reform bill passed a few years ago, and yet there's still perceived problems. But you always have people saying, "Well, we just passed legislation on this. Let's see how that works. Let's give that time to play out." And so, I think that's and frankly, there's always fatigue from any issue. So again, not to pour cold water on things, but I don't think revisiting that issue anytime soon is likely. But I certainly think it ought to be revisited in the context of the overall copyright reform. The issue that Michael pointed to, that you can violate the DMCA when what you're doing doesn't violate in any way the copyright holder's interest in the work, seems pretty strange. And I always, when I explain this to students every year, I just get universal views of bafflement. So why would that be the case?
Right.
There's at least some willingness to accept, I think, that if you have a digital lock and it's preventing you from engaging in piracy, okay, maybe that's a valid policy objective. But if it's preventing academics from engaging in media literacy, or it's preventing you from using your own hardware that you bought, the law tends to lose credibility really fast in those circumstances. And some of the early big cases were examples like that, right? They involved a garage door opener where somebody was trying to use an aftermarket remote on their opener, or printer toner cartridges, right? These are not cases about piracy.
Right. And this seems like a bigger problem perhaps to address if we're looking at the way government processes work than is some sort of streamlining of copyright registration. If you've got more and more devices out there, be they garage door openers or printers, or recently in the news, and we've talked about these on the show, the Renault battery in the car, where you have to, the battery stops working if you haven't made your payments, or having K-cups that are not conforming to the, not actually manufactured by Keurig in your coffee machine. This is just the tip of the iceberg for, a flood of litigation over devices that have software in them with locks that can't be undone. Venkat, do you think that we're going to see some reform on this, or are we going to see a whole lot of pain first?
I don't have a great view being in the Pacific Northwest. I'm not so close to the discussions, but my guess is reform would be slow coming. My impression is that it's just, things seem like they take a long time, and this wait and see attitude is probably a typical response that might come up. And on the other hand, I think it's curious to see public pressure, and to what extent public pressure plays a part in sort of mediating these issues. I know with the Keurig coffee replacement canisters or whatever, there was a fair amount of public pressure in response to that. And I don't know to what extent that actually affected the company's behavior, but these issues are more and more seeing the light of day. And I think the internet as a whole is playing a bigger role in exerting pressure against companies. So perhaps that might that might be increasingly be a factor going forward in mitigating against abuses of this sort.
We should underscore, and I should have you explain more, maybe Matt, that if you do circumvent a digital lock under the DMCA without an exemption, there can be felony liability for that, correct?
There are, yeah. So just like in regular copyright, we have both civil and criminal penalties. And generally the criminal penalties only operate when there is some sort of commercial impact or motive. Although we have seen over the years that the threshold for when that operates has sort of functionally been reduced. There was a famous case years ago where a guy was running a swap website for basically not for profit, but of course he was able to access the stuff on his site, and he beat a felony prosecution, and so Congress promptly modified the rules so that felony cases could be that wouldn't happen again, to close what was perceived as a loophole. So yeah, I mean, if one is doing sort of unlocking for profit, then certainly the potential for criminal exposure is there, and these are the things that worry me about just the general credibility of the copyright system, because if people are going to say, well, it's my phone, I should be able to do with it what I choose, that's kind of hard to argue with, and it doesn't help it doesn't help the legitimacy of the perceived legitimacy of the system. But yeah, that is true. There are relatively few DMCA criminal prosecutions. Mostly they tend to be, in cases that you would think they ought to be brought, criminal enterprises doing sort of large scale sale of mod chips and selling batches of games for profit, right? I mean, that's pretty much a run-of-the-mill piracy operation, and it would also violate the unlocking if you're modding the chip inside, game consoles, for example. But in other cases, whether it's phone unlocking or selling people attachments so they can buy aftermarket K-cups, having potential criminal exposure there, I think really is not the right way for the copyright system to go.
No, doesn't seem that way. Michael, any thoughts before we start talking about net neutrality?
Oh, no, I'm always ready to move quickly to net neutrality.
Let's move quickly to net neutrality. During its initial comment period, the FCC got more than 1.1 million comments from people concerned about this issue. Where do things stand now, Michael?
So procedurally, where things stand is that the comment period closed. Now we're in the reply comment period. That ends on September 10th. And then in theory, the FCC has all the information it needs. It sits down and it writes a rule. In practice, they just announced actually today that they're going to do a series of roundtables here in Washington after the reply comment deadline. So in September and probably October as well. And what we're looking at is a situation where two things are happening. One is the day when a decision, rules might actually come out, it's probably moving towards at least the very end of this year. And then the question is, what are those rules going to be? And I think the good news, what we're seeing right now, is when this proposal first surfaced this time around back in April or May, it looked like it was going to be a very bad proposal. You may remember there were a lot of stories about how the rules, what were purported to be net neutrality rules, were going to allow fast lanes and slow lanes online and ISPs to charge people to charge edge providers to get better service. And what we've seen is a slow and steady evolution towards an understanding that that is a real problem. We've seen President Obama came out this week to talk about how fast lanes and slow lanes are a problem. We've seen members of Congress in both the House and the Senate step up and say this is a problem. Even today, there was a press conference where Chairman Wheeler has been saying that this is a problem. And I think that, if you were talking to somebody in Washington, this was surprising to me, but, in January of this year, I think there was an evolving conventional wisdom that 4 years ago, people cared a lot about net neutrality, but it was an issue that's time had passed and there wasn't that much public interest. I think what has become crystal clear to everyone involved, you said 1.1 million comments. It's been all over the place. Is that this is something that people really, really care about, and doing this right is going to be largely what this FCC is judged on, whether or not they actually create both rules that are strong and protect net neutrality, and they do it in a way that will actually survive court challenge, so we don't have to do this again in 2 or 3 years.
So, Michael, what do you think about the recent statement from the cable companies that it's really not they who are the gatekeepers, but large sites like Google who control all of our access to things, and they're the real net neutrality threat?
Yeah, so this is something they trot out every time, and I think that we can have a conversation about whether or not there are websites out there that have a lot of sway and have a lot of influence as to what people do. But first of all, the nature of that influence is fundamentally different than the company that connects you to the entire internet, right? If I want to do a search and I don't want to go to Google, I can immediately go to Bing. If I want to connect to the internet, I may only have one option. If I have more than one option, it's going to be a huge process to make the switch. But more importantly, net neutrality, the issue of net neutrality is all about that last mile termination monopoly. So the issue at hand when we're talking about this is the company, that one company that controls your access to the entire internet. And so there's no routing around them. If they make a decision, that's what your internet looks like. And so, we hear all sorts of bogus arguments from the cable companies about this. That is one of them that I will include in the bogus argument list.
Matt, do you think that there's any way, if the FCC moves forward with its proposed rule, and obviously we've got a lot of comments and hearings and discussion before that actually becomes a done deal, if it does, do you think that there's any way that companies are going to be able to do preferential paid deals with certain providers and that winds up being a good thing?
So we have seen some of that thus far. And, certainly there are circumstances where, a particular preferential arrangement with, one service and one broadband provider may, provide short-term benefits to customers for, content gets co-located closer and so on. Those if those are the exception to the rule, it's not nearly as problematic if those if those become the rule, right? So a few here and there, if they are sort of ancillary to the general thrust of what's going on in the marketplace, I don't view as that problematic. But if it's apparent that can be done and done in a way that's discriminatory, then I do worry. And certainly in the short run, I think my sense is, and I'm admittedly not as much a telecom expert as some other folks, so you have to take my opinion with a grain of salt. But my sense is that the regulatory framework doesn't inhibit that. The deals that we have been seeing getting struck are permissible under the current regulatory apparatus, and I think the FCC needs to think very seriously about whether or not that's something they want as an industry-wide practice.
All right. Well, yet another thing where we're going to be seeing a lot more on this in the next month or two. So stay tuned. Hey, Venkat, you have some really interesting stories up at the Technology and Marketing Law blog that implicate First Amendment issues and cyberbullying laws. I'd like to get to those before we wrap up the show today. The first has to do with a public school teacher who was blogging not anonymously, but pseudonymously. You could probably put 2 and 2 together and figure out from the pseudonym the teacher was using who the teacher was, and was saying some not very nice things about students in the posts. How did that decision come out?
Predictably, she lost. She was a public employee, and I think public employees have a pretty difficult road when they allege that they were fired for something they said. And I think Eric's follow-up comments, basically, she was venting, and she said, in the old days, and I'm paraphrasing, in the old days, I used to, spend a lot of time and energy on grades, and now I wish I could just really be honest. She was kind of losing energy for her teaching, and she called her students and her parents and their parents a bunch of names on this pseudonymous blog that a reporter found and started digging around, and somehow the school district put two and two together, perhaps just based on context, and found out that she was the author of the blog. And she brought a First Amendment claim saying that her firing was retaliatory, and the court said that, you have to show, as a plaintiff, you have to show that you're speaking out on a matter of public concern. And there's this kind of wishy-washy balancing test where the court asks whether the public's right to know and your right to speak is outweighed by the employer's interest in efficiency. And here the court said that her blog was not really on a matter of public concern in the first place. And there are a ton of these kinds of cases, and they're always fun to blog because there's just, people seem to vent, and they love venting about their job, and people get fired all the time, both public and private employees. And for the most part, it's rare that an employee in this circumstance wins their claim against the employer, and this case is no exception. And I liked Eric's follow-up comments, which basically focused on the fact that as a teacher, do we really want to have people teaching that, everyone has a dark side, but, here I think the teacher's dark side was really made one question her fitness for teaching. And I think there were other examples of adjudicators and nurses and healthcare workers, all who sort of say similar things, and they all pretty much end up, when they sue, they don't fare particularly well.
Matt, do you think this was rightly decided, or should there have been a stronger acknowledgement that a teacher, when off hours, even if they're calling kids jerks and rat-like and dunderhead and whiny, simpering grade rubber with an unrealistically high perception of their own ability level, pretty insulting stuff about the kids. Do you think there's any sort of First Amendment issue triggered there?
And speaking strictly in my personal capacity, I don't even hold myself out as a First Amendment lawyer, but I do consider myself a First Amendment zealot. And nevertheless, I don't really think that this was what the First Amendment it was sort of principally focused on. Yeah. I mean, first of all, no educator should ever be using that language about their students. So whether it's First Amendment or not, it certainly shows a lack of judgment. But yeah, no, I mean, I'm inclined to defer to the courts here. I'm just another bystander with an opinion.
Yep. The name of the blog was "Where Are We Going and Why Are We in This Handbasket?" So clearly the teacher here has another career ahead of her as a writer of snark online. She's good at that. Let's move on to another case that you wrote up on the Technology and Marketing Law blog, Venkat, where the First Amendment did prevail. And in this case, it undid a criminal cyberbullying statute in New York. What happened here?
There, basically, a student created a Facebook page and posting details of his classmates and their sexual practices. And he was prosecuted under the cyberbullying statute. And the conviction was overturned because the court said violated the First Amendment. This is also, I think these types of cases are also somewhat typical. There are a ton of cyberbullying statutes out there in various state levels. And, every month or every couple of weeks, we always see a case, Eric and I, that involve an application of that statute that is really ill-suited and creates a lot of First Amendment problems. And I think cyberbullying and harassment in, what in the old days might have been sort of conversation between classmates, perhaps somewhat harsh conversation, now often gets turned into cyberbullying or a violation of a cyberbullying statute by a probably overzealous prosecutor, and that's exactly what happened here. And I think really the particular part of the statute that was problematic is that it gets at communications that are intended to harass or annoy someone, and there's a little bit of gray area as to whether you can criminalize or even prescribe somebody when they intend to cause severe emotional distress. I think harassment law and First Amendment law have a well-recognized tension, but this falls well outside the bounds of that. When you start getting into saying that annoying speech can be criminalized or even prescribed, I think that most people recognize that as problematic from a First Amendment standpoint, and even the government did in this case, and virtually acknowledged that the statute violated the First Amendment.
All right. Well, thank you for bringing us up to speed on that. I think it's time for us to move to our tip and resources of the week. Our tip of the week is right in line with what we were just discussing. And that is that although this particular statute in New York was invalidated as unconstitutional under the First Amendment, there are various other states with similar statutes where these are perfectly viable, and California is one of them. In particular, the tip has to do with, if you're someone who's prone to making prank calls. I know we have some jokesters who listen to the show, or if you might know children who might be prone to making taunting or annoying phone calls. We have a law on the books in California that criminalizes that activity under certain circumstances. And involves penalties of up to 6 months in jail and $1,000 fine. It's a misdemeanor liability. So again, it's going to depend on whether you encounter a prosecutor who is going to enforce this law, but it is on the books, and it has to do with harassing and annoying conduct on the phone. And the way it works basically is there's a couple of components to. If the calls are repeated and they're harassing and annoying, that would be sufficient under the statute, it appears. Also, if they cross the line from annoying and harassing into obscene, then they don't even need to be repeated. So the language of the statute goes. So if you're a Jerky Boys fan or anyone else who is a fan of prank or annoying phone calls, and you're in California, or perhaps there are other states. I have not done a 50-state survey of these kinds of laws. Other people have, but I do know that here in California, we have a law in the book that attempts to and does impose misdemeanor liability for prank phone calls, or harassing and annoying phone calls. So that's our tip. And then our resources are twofold. One is, I forget, I think it was Michael, if not, it was Matt, who pointed to this in your Twitter feed. It's this great timeline from the Copyright Office that is the history of copyright, every significant event as far as the United States Copyright Office is concerned anyway. Who wants to take credit for finding this, Matt or Michael?
Everybody gets credit for finding things on Twitter, right? But I think I did point to that. That was it. Just watching that move, that was quite popular. It's a really fun toy to play around with, and there's a lot of great stuff there. I look forward to pointing my students to that.
Right.
Yeah, and can I just plug? It's actually built on an open platform that the Knight Foundation has done. It is so easy to make a timeline that looks that good. It's just timeline.js. I know we used it. We have a website, whatisnetneutrality.org/timeline, and it's basically the same timeline but for net neutrality. To make this thing, just if you're thinking about doing it yourself, all you need to be able to do is type things into a Google spreadsheet.
Oh, that's so nice.
It's so easy.
That would be useful for educators everywhere. And for anyone interested in copyright law or copyright principles, this is a really great way to sort of take you through how we got to where we are. And a reminder that copyright terms in the United States when they first came into play were 14 years long and not life plus 70. So there's quite a bit of good stuff in here for anyone interested in those issues. Also, for anyone interested in the issues that we discuss on this show, Venkat's co-blogger Eric Goldman does a great job, obviously, of teaching his internet law courses at Santa Clara University, and a great job of making a whole bunch of his teaching materials available and transparent. Right now, his 2014 internet law syllabus and updated casebook is available for $8 in a DRM-free PDF format. Eric makes his exams available too, which are always a hoot and a half. And this is just an incredible resource for anyone, I think, interested in internet law whatsoever. So he's got all kinds of cool things in here, including new this year, a cheat sheet on the DMCA, how the DMCA's online copyright safe harbor has failed, how the Silk Road ruling will hurt online commerce, all of the cases that are used in his course and analyses of these cases. So it's just a really cool tool. And if you're interested, it's just $8. So go check that out. Also, I'm reminding myself as I look at our spreadsheet that we need a second MCLE passphrase before we go ahead and wrap the show. Let's make that Jerky Boys, or anyone who even remembers who they are. And, so if you need, yes,
all my shoes and all my glasses, so I have them.
Yes. So we'll just mention too that if you are interested in continuing legal or other professional credit for listening to or watching the show, head on over to wiki.twit.tv. We've got a page there under the This Week in Law show, of course, with lots of information on how you can bring that about for yourself. What else? That pretty much does it for us, guys. I'll ask you, please to get in touch with us between the shows. I'm Denise at twit.tv. My co-host Evan, who will be back next week, is Evan at twit.tv. You can send us tweets. I'm D Howell on Twitter. Evan is Internet Cases there. That's also his blog. So let us know things as they pop up on your attention radar so that we can think about putting them on the show. Let us know about guests that you think we should have on the show. Let us know what you thought about things like monkey selfies and who has the copyright in them, and other things you think we should be paying attention to. We also have Facebook and Google Plus pages that you should check out. And you should also go to twit.tv/twill if you want to go back into any of our shows from years and years ago and try and figure out the difference between MP3 tunes and mp3.com. We'll try and keep that straight ourselves as we go forward. It's always fun to see how stuff that was resolved decades or more ago can still have currency today as we try and figure out all of these issues related to technology and the law. And we couldn't do this show without the help of our great panelists who come each and every week. This week has been no exception and just a wonderful discussion. Venkat, thank you so much for joining us again.
Thank you.
Enjoy the rest of your summer in Seattle.
Will do.
And please come join us again soon.
Thank you.
And Michael Weinberg, again, so great to pick your brain on all issues related to 3D printing and net neutrality and all the other great stuff that you guys pay attention to at Public Knowledge. Any particular issue or place you want to point people towards where they should be taking action or looking at an issue that they may not realize is very important to their daily lives?
I would say if you haven't weighed in on net neutrality yet, definitely go to publicknowledge.org and click on Act Now. We've got actually a cool new tool that makes it super easy to call your member of Congress and tell them what you think about net neutrality.
That's wonderful. Thank you so much,
Okay,
Michael, and enjoy the rest of your summer.
Thank you very much. You too.
Great to meet you, Matt Schruers. I'm envious of all your students at Georgetown. Seems like you'd be a great person to hang out with for a semester or two.
Well, thanks. I hope my students agree. It's good to be here.
Tell us a little bit about the program on communication, culture, and technology. That seems like a great thing to be able to take advantage of while at Georgetown.
Well, so it's an interdisciplinary program in the grad school, and it attempts to bring together a variety of different educational resources and backgrounds to give students a more sort of robust tool set for whether it's going on to do further academic work in the form of a PhD, but also, I've often run into graduates of the program working for, companies and agencies and institutions here in DC. So it's, as I said, it's sort of interdisciplinary, a sort of multi-purpose degree exposing students to all sorts of interesting facets of communications, tech law, tech policy, sort of technology in society from a variety of different angles. So I work with a lot of great faculty members there.
And do you write regularly at SCOTUS Blog, or was your Aereo piece one-off for them?
That was a one-off. I think I write regularly at Project Disco, and I imagine they right. saw me ranting at length there and said, well, he obviously has an opinion on this subject. Why don't we give him some space when the case comes out?
Right. Absolutely. That was a good call on their part. And for anyone who's not already reading Project Disco, you need to be doing that. It's a great blog. All right, guys, this has been really, really fun. We so appreciate your time and your insights, and we appreciate the time of everyone who's joined us today. We'll be back next week for This Week in Law, and we will see you then. Take care.